Now that it's 1 minute after the top of the hour, I want to now introduce the founder, president, and one of the walking encyclopedias of this stuff on the face of the planet. We have Fred Gray from Gray Systems. Fred, take it away, my
Thank you,
man.
Jeff. Welcome everybody to our little discussion. And I'm going to share my screen and put my PowerPoint up here for you just a moment. A couple of comments before we start. First of all, if any of these you need further in-depth instruction, need to consult with your association attorney. This is not legal advice. This is educational,
Right.
instructional. It's also not continuing education for any part of the profession. Uh, and I came up with this topic based on a good number of questions we received in recent weeks about situations where we have owners, members who refuse to comply with the documents, and what can we do about them? I get some rather odd answers sometimes, which I'm not going to repeat here in our situation, but you can take some really corrective action sometimes and a physical nature, but that's not the best way to solve the problem at all.
No.
And that's what we're going to touch on today. As we go through here, as Jeff said, if you have questions or comments, you're welcome to enter that into the Q&A session or even the chat feature as well, and we'll address any of those. We also have some related questions that I'll get to at the end of my session. It shouldn't be more than 45 minutes or an hour out of your day today, but you're welcome to participate any way that you'd like to ask questions, whatever. And at the end, as always, we will let you know that if you have questions after the fact, you're welcome to contact me or Jeff, either one, and we'll get your questions answered one way or the other. If we don't know the answers, we'll research it, try to find it for you. And with that, I'm going to share my screen and talk about enforcing the documents. It's incumbent upon us that live in community associations of any type. I live in an HOA in our small town north of Orlando, Howie in the Hills. I swore I'd never do this again, but I'm here now for 4 years, thereabouts. But maybe I can get good along with it as well. When you buy property in a community association, whatever type, it might be condominium, cooperative, or an HOA. You buy the property subject to whatever guidelines exist in your local governments, the state, federal rule, and mores as well. We also buy property subject to the documents governing that community. And inherent in our legal system is the principle that when the developer forms a community association in compliance with the laws recognizing the three types, condo, co-op, or HOA, in order to create that association, we record the governing documents on the public records in the county where the property is located. And every county has a clerk of the circuit court, or sometimes it's called clerk of the courts. And that body, that official, is responsible for maintaining the public records in each jurisdiction as well. And once those documents are recorded and put on the public record, the entire world is deemed notified. And there's no defense that says, I didn't see the documents, I didn't get to read them, so I don't have to follow the rules. As well, but the fact of the matter is, when you buy property in a community association, whichever type it might be, then you're bound by those documents. And whether you read them or not, our law presumes when you go to closing and purchase the property, that you have read the documents and you've agreed to abide by them as well. And
Hey, folks,
uh,
Fred, let me interrupt because we'll answer the questions at the end, so you can just type them in, and Fred, you can just keep on going. We'll address them towards the end of the
okay,
presentation.
I was trying to follow that. Thanks, Jeff. But anyway, when you buy property in the community association, you agree to be bound by those documents and comply with the documents. And that's our legal system, again, that presumes that. Pull this back up here. And the board, the association, is obligated to take whatever measures.
We lost your
Uh,
slides. We don't see your slides anymore.
Here we go. How about now?
Not yet.
Okay.
Hey, folks, technology is wonderful when it works.
Mhm.
We'll get it back up there in a half a second here. Yeah, right now we just see your beautiful face. And okay, now we see them with the thumbnails on the left with the one, two, three,
Okay.
4, 5.
Uh,
There we go.
But the whole concept is based on compliance with the documents. I know, as I said, I live in an HOA. When I bought here 4 years ago, I was not excited about it, but I did read the documents before I signed the contract to purchase the house. Some things I don't like, but I decided I could live with them. But I also like the fact that they place restrictions on what we as owners can't do, what we have to do to maintain uniformity and consistency with the appearance of our property as well. And I feel that those attributes actually attach a value to the property, and making sure that those are enforced adds value to my property. And I would not like it if somebody didn't enforce the documents, the association itself and the board. It's incumbent upon the board to do that. So part of their fiduciary responsibility to make sure everybody complies with the documents. Also, the law presumes if we're going to enforce the documents, which we're going to talk about that process in just a moment, that we must afford those that we're trying to enforce the documents or make them comply with a process called due process. Due process is a concept in our legal system. To punish somebody for wrongdoing, we have to give them an opportunity for a hearing and an opportunity to explain themselves and to try to avoid the punishment, whatever that might be. That's our legal system for criminal activities in our country. And that's the due process part. And we're going to see that in a few minutes as well. Also, enforcement is conditioned on the efforts of the board and the association through the board, being reasonable, uniform, and consistent. That's the reasonable man rule, reasonable in all of our actions. We apply it uniformly, and we are consistent in applying the rules as well. And obviously, the best thing can happen is when you have a violation, we provide the person that we believe is in violation with a notice of violation. And in that notice, we first of all give them an opportunity to correct the problem. And voluntary correction is the best solution where there has been a violation. And if we send them a letter, and it doesn't have to be a nasty letter, it can be a very comforting letter. As you may not be aware, our rules say this, and you are in violation of that rule, and we're going to request that you comply with the rule or the provision of documents, whatever it might be, and give them a deadline. for compliance. The deadline should be based on the inherent dangers in the violation. If it's not creating a danger to the community, we can give them 7 days or 14 days to correct the problem. If it's something structural, visual, or something like that, it may be a longer or shorter period of time. If it's something that's inherently a danger, creates a dangerous situation in the community, we can request that they resolve the problem immediately. And you have to be consistent with that as well. But we should always write a nice letter of violation first, give them the opportunity to voluntarily correct the problem. If they don't correct the problem, then we have to take additional action. The ultimate solution to a violation is going to court. Obviously, we would rather not go to court. That's why all three of our community association laws, conduct, co-op, and HOA provide us some additional tools to try to remedy these problems. We're going to see those in just a few minutes. But the ultimate recourse is to go to court. And most association boards and members are reluctant to go to that last step for two reasons. One, it creates animosity and conflict within the community quite often. The other problem is that it costs money. Once you engage an attorney to enforce the documents, you're going to incur legal fees. There's also costs involved in going to court, filing fees, other fees that may be involved there as well. So many times the board and the association owners are reluctant to go to court. However, in situations where there's no other solution, it's incumbent upon the association to take proper legal action to make sure everybody's in compliance. If for some reason we don't pursue action in that event, and later we find somebody else is doing the same thing, and we later try to enforce it against that poor person, we may find that we're unable to enforce that provision in the documents based on a principle called equitable estoppel. That's a legal principle that says stopped in equity. Equity refers to our court system. And in that situation, if we don't enforce the documents for some period of time, and then we come back later and say we're going to enforce the documents now, if that's challenged in court and the court feels that we did not adequately provide notice of all the legal requirements, comply with that, the court can say to the association and board, you didn't enforce that against Fred, now you can't enforce it against anyone. And that's called equitable estoppel. And that's one of the dangers in not enforcing the documents. There's also been discussion and rumors about owners bringing lawsuits against the board for failure to enforce the documents, where they feel that they have suffered financial harm because of the board's inaction, and that they may find the board members could have financial liability in that regard as well. If you do go to court, prevailing party in the legal situation is usually entitled to recover all of their costs incurred in the court proceeding. They may also be awarded damages by the court. If the court feels that they have suffered financial harm, the court can award them damages. Also, the court can issue an injunction against the party that they find was in violation. And if the party doesn't resolve the violation after the court finds them files for injunctive relief, then they can find themselves being incarcerated without a time limit for not complying with the court order. So it's a serious decision to go to court, but that is the ultimate recourse that we have to enforce the document. And that goes both ways. If we feel the board as owners, if we feel the board is not doing their job properly, then the members can take the board to court. And if the court agrees with the members, the court can make the board uh, change their actions and bring themselves into compliance with the documents. That usually has to do with enforcing the documents as well, and issues in there. I know in my community where I live, I happen to live in the same town since this development started over 20 years ago. It's part of a larger development, and the original developers are friends of ours, a family that owned the Mission Inn Resort as well. And I promised to stay out of these issues, but they had some issues with the Developer Control Board for several years. And before I moved in and decided to buy here, I got met with the people that I knew that were involved in those disagreements and said, I'm aware of all this, but I will not participate in any of these actions, and got a step back from it. I have been involved a little bit, but because it can get a very personal, some will take all these things very personally, and it's very obvious that it's not something that I want to be involved in. That's one of the reasons we don't like to get involved in court proceedings at all. But it's incumbent upon the association and the board to move forward as quickly as they can. And our legal system presumes that enforcement of the rules and covenants must proceed without undue delay. And that means when the board becomes aware that there has been a violation, they're supposed to do whatever is necessary to cure that violation as quickly as possible. Many years ago, our legislature realized that it was a very serious and lengthy process to go through to wind up in court. So the legislature attempted to give us some relief in the laws regulating our community associations, and originally allowed, in some cases, the board to fine owners for violations as well. Back into about 15 years ago, in 2010, the legislature also gave the board and the association the power to suspend use rights for violations of the documents as well, and for non-payment of assessments. And so that's what we look at next. And that's the authority to impose fines and suspensions. And this is in the statute. This does not have to be in your documents, but I would urge you before you, as a board member or owner, advocate taking this action, review your documents. The documents probably meaning either the declaration or the bylaws, to determine if there are already provisions in your documents allowing the association to take action against a unit owner if they are in violation of any provisions of the documents. The statute provides that the association can impose a fine against the members, tenants, guests, invitees, and suspend the use rights of common property for a reasonable time for the failure to comply with the provisions of the declaration, bylaws, or reasonable rules of the association. And the fine may not exceed $100 per violation. However, the fine may be imposed for each continuing day of violation, not to exceed 10 days, for a total of $1,000. In a homeowners association, the aggregate amount of the fine may be more than $1,000 if so provided in the documents. Condominiums and cooperatives, the fine cannot be greater than, in the aggregate, for each continuing day of violation, it cannot be greater than $1,000. Interesting comment about the HOA law. Back in the mid 1990s, as the HOA regulation was progressing. HOAs were largely unregulated until 1994, when the legislature passed some amendments to the Not-for-Profit Act, specifying that HOA meetings were open to all the members, both board meetings and membership meetings, and the members had the right to attend the meetings and speak, and also had access to the records. And that's where it all started. And so for several years after that, they kept adding more regulation to 617. Finally, in the year 2000, the legislature created Chapter 720, which created the regulatory structure for HOAs. But somewhere around 1995, 96, somewhere in their time frame, uh, I've always observed legislation is moving forward. In my career, my company, in Gray Systems, and 16 years before that, the company that I worked for, we were involved in legislative activities and I felt that the legislature was valuable in protecting our business operations and assisting us when we could get them to do things that we wanted. So I've always observed the legislative activity as well. And I was a registered lobbyist for 40 years as well. But anyway, one of my students that I've had several years before who had also become a friend because we found out we had numerous connections, was a manager of a community in East Florida. And he called me one day, says, I've got a problem with this legislation that's going through up there. And I said, which one? He said, the one about fines. I said, okay, what's your problem? He said, it says the maximum fine is $100 per violation or $100 per day for up to 10 days, a maximum of $1,000. And I said, well, okay. He said, well, if I tell my owner I'm going to fine him $1,000, he'll pull out his wallet and give me $100 bills and say, leave me alone, or write me a check or whatever. That won't phase them. And our documents provide for a much greater fine. And I didn't ask him how much it was. I said, let me think about it. And I called a friend of mine in Tallahassee and we talked about it. So I called him back. I said, my lobbyist friend says that he thinks he can get language put in the law that will let your documents prevail. And he said, what you gonna put in there? I said, the maximum fine is $100 per day, for and up to 10 days of each continuing violation, $100 per day, not to exceed 10 days or $1,000 unless your documents provide otherwise. And he said that might work. So that's why it's in the law. And that's why I said, unless your documents provide otherwise. And I finally asked him what was the maximum fine that could be imposed by their documents. And he said, our maximum fine is $50,000. And he says that gets their attention. So you can see how that might be interpreted differently as well. And then a fine suspension may not levied by the board administration of a condominium or cooperative may not be imposed unless the board first provides at least 14 days notice to the owner and if applicable any occupant, licensee, or invitee of the owner. A person sought to be fined, suspended, and an opportunity for a hearing before committee of at least 3 members appointed by the board who are not officers, directors, or employees of the association, or spouse, parent, child, brother, or sister of an officer, director, or employee. So in condominiums and cooperatives, I'm going to go back to what I said in my opening comments. The best way to handle a violation is to first give a courtesy notice of violation and then give them a correction period. If it's not corrected within that corrected period, or that period for correction, we send a second notice and tell them they're still in violation and they have 14 days to request a hearing before the board can impose a fine. And they have to have a committee I get a lot of questions about the hearing committee. Does that have to be a permanent committee or standing committee, or can appoint one as needed? I always say it depends on the association. If the association is one of those where you rarely have violations, and uh, when there are violations, people usually correct it in a responsive manner. You probably don't need a standing committee. However, if you have a problem with violations and you're constantly requesting hearings, you probably want a standing committee. The HOA world is a little bit different. We'll talk about that in a moment there as well. If the committee by majority vote does not approve a proposed fine or suspension, the proposed fine or suspension may not be levied, may not be imposed, and the committee is limited to determine whether to confirm or reject the proposed fine. They can't change it and say, well, that's too much or it's not enough or anything like that. They just vote yes or no on the fine, and that's their job, and they're done. Once the board receives the committee's uh, decision, obviously, if they say no, then we tell the owner that the fining committee said there's no fine. Uh, there's a question then, can the board give them another notice of violation? And I'm aware of situations where that has happened, and uh, they continue to go back and forth on it. But typically, if the committee doesn't agree, that's kind of like a not guilty verdict in the legal system, and we would not pursue that fine. And if the fine is approved by the committee, the fine payment is due 5 days after notice of approval of the fine is provided by the owner and applicable to any tenant, licensee, or invitee of the owner. A question comes up here about how do you provide the notice of the committee's decision. Uh, the community association world is moving forward into the electronic world today, and owners can now opt in to receiving notices electronically, uh, typically email. The statute does not address text messaging, but I presume text could also be included in electronic notice as well. Uh, I think the board should have some resolution, adopt a board resolution specifying how electronic notice will be provided. When it was originally uh, added to the law a number of years ago, they used facsimile machines along with email. Now facsimile machines are antiquated and out of use, uh, and text is taking over. I'm not sure I like that, but I've always been slow to adapt to technology. But anyway, explore that with your council and see if you can give these notices electronically. But the point I was going to make here is that the owners have to opt in for electronic to receive electronic notice. It's not that the association can make them receive notice electronically. The old standard was U.S. mail or personal delivery. If you provide notice by personal delivery, the person receiving the notice by personal delivery must sign a document acknowledging they've received it. When you mail something and you give the postmarked envelope with proper postage to the post office, it is considered mailed and delivered at that time. And but if a personal delivery, you have to acknowledge it. Email or electronic notice has its own formula for recording when the email was uh, basically handled by our electronic world, when it was sent at that time and date, and when it was sent is considered delivered. That's ignoring the issues related to spam or junk mail and how sophisticated your email system is and sorting through your email. And I've learned from personal experience over the past 12 or 15 years or so that we've been using email on a regular basis, longer than that now, I guess, 20 years. But the daily check the junk and spam folders as well. Things get stuck in there without your knowledge sometimes. Also, some mail systems are very careful about mail that they will handle. I know we have a client or customer of ours we've been dealing with for 20 years, and their in-house email system doesn't like our Gray Systems Outlook mail. So we have a standard procedure in our office when we communicate with them. We use our company Gmail account. They like Gmail, they just don't like our Outlook. That's up to you to make sure that you do get your mail that way as
Yeah,
well.
I'll step in for a second so you could have a sip of water and rest that voice of yours. One of the things, regardless of what email platform you have, algorithms are changing all the time. So, one thing to remember anytime you have or expecting an attachment, like for example, if you receive a certificate of completion for a CEU class, most of those are coming from a business. It doesn't matter what that business is. So a lot of email platforms have these algorithms that are going to potentially flag an email from a business email account with an attachment as a potential virus or potential something. So as Fred mentioned, it doesn't really matter what the organization is. If it's a business email extension and then it has an attachment on top of that, the likelihoods of it ending up in spam or a different folder like promotions tab in your Gmail, those instances, the likelihoods increase. So just keep an eye on the spam folders, as Fred mentioned. Back to you, sir.
Thanks, Jeff. Also, the association must provide written notice of such fine or suspension by mail, hand delivery, or parcel owner, and applicable to any tenant, licensee, or invitee of the parcel owner. And that paragraph it says by mail or hand delivery. Again, check with your counselor to see if they agree that that could also include electronic notice. And again, the owners have to opt in to receive notice electronically and make sure that you do have that properly documented as well. In a homeowners association, it's a little bit different. The board, after the board's adoption of the fine, a notice must be sent to the offending member at least 14 days prior to the hearing committee meeting. The hearing committee is made up of at least 3 members appointed by the board who are not officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. And the use of the term members there refers to the fact that the committee members must be members of the association. I've had questions about that before. They say a member of what? And the legislative intent is that to be members of the association. And the hearing committee meeting is mandatory in the HOA world. And the notice will be sent to the members' designated mailing or email address as set out in the association's official records. And the notice the offending member must include a description of the alleged violation, the specific action required to cure the violation as if applicable, if they can cure it, and the date and the location of the hearing. And a parcel owner has the right to attend the hearing by telephone or other electronic means as well. Everything we can do now at meetings, we can do virtually. And we'll see more about that in later discussions as well. And so that can be virtual. And after the hearing takes place, the independent committee must provide written notice to the parcel owner at his or her designated mailing or email address, and applicable to any occupant, licensee, or invitee of the parcel owner. Of the committee's findings related to the violation, including any applicable fines or suspensions, the committee approved or rejected how the parcel owner or any occupant, licensee, or invitee of the parcel may cure the violation if applicable. It appears, and based on the language in the statute, the HOA statute, that the committee has, the hearing committee has a little more flexibility in how they impose penalties on the person in violation as well. So that is the fining process. And we do impose a fine. They are enforced and collected through county court. That's what we call a small claims court in most cases. For condominiums and cooperatives, fines may not be a lien on the condominium unit or cooperative share. For homeowners association, a fine of less than $1,000 may not become a lien against a parcel. So let the fine get up to $1,000 in the HOA, so we can have a lien right. Not having the lien right for condominiums and cooperatives does complicate the collection procedure. If you go to small claims court, there may be some small minor cost involved that can be tacked on to the lien amount as well. And when you get usually in small claims court, you're going to get a judgment against the owner, which means you have to attach assets. Usually that's done through law enforcement as well. You don't have to have an attorney to go to small claims court. However, it's highly recommended that you do utilize one just for advisory services only in there as well. It does make it difficult to collect the fines. Oops. Well, I didn't include it in my handout here, but I'm going to talk about it. Also, I'm not sure what happened to that. It was in my original presentation. Also, the association can suspend the rights of owners to use the common elements in condominiums. You can't suspend the right to use the limited common elements for the owner's right to use that, or ingress or egress to the association, or utilities, or elevator use. In HOAs, you can't suspend the right of ingress and egress to the association as well. And you go to suspend use rights, you go through the same process you go through to impose a fine. You have to have the opportunity for a hearing in a condo or co-op, or you must have a hearing in an HOA. And the suspension of use rights can be for a specified period of time or until the problem is corrected or fine paid. Also, if an owner is delinquent in the payment of any assessments for an HOA or co-op, you can suspend their voting rights for non-payment of assessments. You can also suspend their use rights to the common elements as well. Both of those provisions were added after the crash, financial collapse back in 2008 and 9. And the idea was to give the associations a little more tools to use and collecting delinquent installments or assessments as well. My slides ran out, Jeff.
Yeah, we don't see your. Oh, you're finished with them? Got it. Okay.
And for condominiums, if the owner is more than 90 days delinquent and the total amount due is $1,000 or greater, we can suspend voting rights and use rights as well. And when you suspend use rights, that creates a greater burden on the association. And now we have to have, if you don't have controlled access to the facilities, the pool, the clubhouse, fitness facility, whatever, and you have to have pool police and clubhouse monitors as well. So that doesn't have a great deal of impact in there. And the correcting the problem as well. Suspension of voting rights has no impact on getting delinquent owners to pay. They weren't voting anyway, so telling them they can't vote is not going to cure any delinquencies out there at all, and makes it kind of superfluous action to take against somebody if they're delinquent. And that, again, we do the same thing, suspend use rights for violation of the documents. And in both cases, you have to go through due process to do that. And that pretty much covers what I wanted to cover. We're going to address the questions. Jeff,
Yeah,
uh,
we have a few. You want to? We can cover some even if they're not related to the topic because we could find a way to make them related, I think.
I guess we can.
Yeah. Kirsten is asking, can a COA, a condo, require a yearly update for ESA letters and require vet and vaccinate and vax records for ESAs or service animals? So I guess that's going to be related to what's in your documents, I suppose, even though it's more of a statute question.
Well, ESI is not controlled by Florida law.
Okay.
Okay, that's a federal issue. The Department of Housing and Urban Development enforces the Fair Housing Act. Fair Housing Act is the area where most of support animals come in. Their position is once an owner has supplied you with documentation for an existing animal, they don't have to do anything else. So it's difficult for them for the association to require that be updated. If the
Okay.
owner replaces the animal expires, dies, pet goes away, the owner would have to document a new animal under the ESA guidelines. But mention this, those guidelines are constantly changing.
Yeah.
They're fluid as the HUD gets hit by court cases and court decisions that come in impact what they're doing. They're constantly evolving. So before you do anything like that, check for yourself. You can do a lot of this research on your own,
Yeah.
and also don't hesitate to contact counsel. Almost all, I never like to say all, I'm sure it's the case, but almost all of the attorneys that specialize in community association law are very familiar with the ESA guidelines as well,
Too
and they're
familiar.
like good guidance on that.
And that's why we call this guy the walking encyclopedia. All right, hang on. Question number two, also from Kirsten. Can you please give us an understanding of the pros and cons of adding or removing Kaufman to your docs, Kaufman language?
Yeah. Again, Kaufman is language that comes from a court decision going back years or more now, where the attorney somewhere along the way put language in condominium documents first. Uh, Actually, it was cooperative documents first, and later condominiums and HOAs. Attorneys have copied that, put language in the documents that says these documents hereby incorporate all future changes to 718 for condominiums, 719 for co-op, or 720 for HOA. The advantage in doing that is that you get the benefits of the changes without having to amend your documents. The disadvantage of doing that is you're subject to those changes without amending your documents. So you have to evaluate how you want to do that. I prefer if there's a change that affects our documents that we amend the documents to reflect that change and how we want to handle that. The problem with that philosophy is getting people to vote. It's oftentimes hard to get the owners in sufficient numbers to participate, to even have a quorum at a meeting. And most documents now provide it requires at least 2/3 of the owners to amend the documents. Some of the older documents have a smaller number, but it's very difficult to get that many people to participate in the amendment process. So having that language in your documents automatically incorporates those changes as they're made. So I think the association has to decide which way they want to go with that as well.
All right, this one is a little bit of a chapter in a novel, so let me do the best I can here. We are a cooperative in Palm Beach County on South Ocean Boulevard. We have a shareholder, and for those of you who are not familiar with cooperatives, that is the correct term, shareholder of a cooperative, who refuses to provide a copy of their unit key for use by the management company in the event of an emergency and they need to gain entrance into the unit. Our house rules require this. This person will not comply, saying they don't want anyone else accessing their unit. As a cooperative, shareholders do not own their units. They own a share in the full cooperative. Do you have a comment on that? It's not really a
Your
question,
observation
more of a
is
statement
that,
than a question.
yeah, your observation is very accurate. The shareholder does not own any real property. However, our legal system treats the shareholder just like, or the share, rather, just like a deed for
Yeah.
real estate tax, for real estate tax purposes, and also their owners' rights as well.
Yeah.
The ultimate solution, well, so one thing that you mentioned in the question, it said, I think you used the word rules, require that the owner, the shareholder provide a key. Um, the only way to enforce that is for that to be a condition of the proprietary lease in the co-op. And then you have to take the cooperative owner, shareholder to court. That's basically the only way to enforce that. And of course, you can fine them, but well, do that over and over again. But
Yeah.
they maybe that person that don't care, doesn't care. $1,000 late.
Sometimes fining could be a waste of time. I remember back when I was on site, we had a woman who lived in Manhattan, used to paying astronomical parking fees for all the stuff she liked to do. So she would go ahead and just park on when there would be a show at the theater, she would park wherever the hell she wanted. And she would get a ticket from the association. And I will to this day remember, I could write a book on this, some of the things that I hear. She said, "What do I care? I used to pay three times that amount when I would go out, out for the night in Manhattan. I'll pay the fine. I don't care." It was just quite comical.
Yeah,
Quite comical.
and that may be the case with this person.
Could be.
We don't know.
Could be. What type of interest can be charged against a delinquent fine payment? Is there a limit on the amount of interest that can be charged over time?
The statute provides that interest can be charged as allowed in your documents on past due assessments. And the term assessments, it does not mention fines. There's ongoing debate about that, whether you can charge interest on fines or only on assessments.
Yeah.
I feel, based on the language in the Condominium Act, which says assessments only, that we can't charge interest on a fine. But if the documents don't provide for interest, the association can charge up to 18% interest on delinquent assessments, and the fine is not an assessment.
Okay. Let's see what we have here. Can the courtesy letter date for what you were speaking about earlier, can the courtesy letter date be the same day as the board meeting? For example, can the board send a notice to the homeowner today and tonight vote to send the meeting to the fining committee in 14 days?
Well, first of all, is it a condominium or an HOA?
Jennifer, can you elaborate on that if you are still here, please?
But I'll answer it both ways.
Okay.
The if there is no requirement that we send a courtesy letter. Okay. That's the recommended practice, that we send a courtesy letter with a
HO.
reasonable
She just
time.
replied HOA, by the way, Fred. Okay. Thank you, Jennifer.
Uh, I'm sorry, what's it?
I'm sorry to interrupt, but she replied with HOA. But back to you.
Okay, okay. There's no requirement that you send a courtesy letter. That's it, as it says, a courtesy letter. If the board feels that they're going to, uh, there's been a violation, and they can, at a board meeting, impose the fine. And then it automatically goes to the hearing committee. You have to have at least 14 days notice of the hearing committee's meeting. Okay? So yes, they could send, if you want to call it, a courtesy letter on the same day, but that's not required.
Okay. Okay. Denise has a one sentence question, probably relating to her question earlier about the cooperative and the fines. What can you do if the shareholder won't pay the fine? Is this, Fred, so is this similar to like in a condominium, for example, where you can cut off the quick gate access and make them go through the guard gate all the time where there might be a longer line? Is it similar types of things that you can take away, like amenity, taking away certain amenity privileges
They don't,
in a cooperative?
yeah, yeah, I'm clarifying my thoughts again. The failure to pay, I remember exactly, uh, a
And this is
fine,
this is for shareholder in a cooperative. So put the cooperative hat on.
that would, yeah, um, yeah, we can yeah, we can suspend use rights in a co-op. Yes, the board can do that. Obviously, going through the process again and having the committee having an opportunity for hearing and
Yep.
to back up. I get ahead of myself.
Okay.
There to suspend use rights.
There aren't that
Yes,
many cooperatives out there. We can look it up if we need to.
yeah.
Get back to her.
I'm trying to get the right language. I'm straight
Oh,
in my mind.
yeah.
We can suspend use rights. We'd have to have if it's for delinquency, we don't have to have a hearing. It has to be voted on at a board meeting, and we can suspend their use rights, and we can impose uh, suspend their voting rights as well. But, and for co-ops, it would not require that we have a notice.
Okay.
Be done by the board, and doesn't have to have a hearing.
See, that's what happens, folks, when you have so much knowledge in your head. You have to flip the Rolodex back and find that find where it's filed.
Yeah.
All right. So Kirsten is back with a question. Can a condo, a COA, suspend usage of an additional entrance as long as ingress and egress is provided through the main entrance that is monitored by 24/7 security? For an example, there is a back door in addition to the main entrance.
Yes, they can suspend the use of the entryways. You can't refuse them the right to ingress or egress in the community, but you can take away their use rights for the where you have fobs or barcodes or whatever to get in.
Similar
Yes, you
question.
can do that.
That's back to
Yeah,
the convenience aspect. You know what I mean? That's
right.
similar.
Yeah.
Well, that that's all the questions that are in there right now. Does anybody else have a question before we head out for the day? For those of you asking earlier, we will have another email that goes out tomorrow, thanking everybody for attending. In that email, we'll put a link so you can save some of the slides that Fred used today. We're also recording this. This will be on the Gray Systems website within a couple of business days for you to review, along with some of the few that we've done over the past couple of months. And anything we do in the future, it'll be on graysystems.com under the newsletter section. Keep in mind, too, that we continue now. We've expanded our program where we create and manage and maintain websites for community associations of all types. We can help you out with that. Who better? Considering that this gentleman who just spoke with you for the past hour or so pretty much wrote the book and is the reason why we have CAM licensing in the state of Florida. Fred, anything you want to say before we head out for the day?
No, I just want to say thank you for being here. And if you need have any questions, don't hesitate to contact us. Thanks, Jerry, Jeff.